So thanks for reaching out to Blacksburg Law and considering working with us. I know that you've got an upcoming meeting scheduled. One of the questions that is most often asked is, what's the difference between a will and a trust? And it's a great question. It gets to the heart of what estate planning is, which is that you're really crafting a set of instructions for somebody to be able to follow and to have the legal ability to follow them or to act on your behalf. And that legal ability to act comes in the form of documents that give somebody the legal authority. And estate planning has a number of documents, a number of vehicles that are used in order to allow somebody to act on your behalf. A will is a document that allows somebody to act on your behalf after you've died. It only works after you've passed away. And the document can be used to name who you'd like to be your fiduciary, personal representative, executor, whatever you want to call them. And also where your stuff goes after you die, who gets what. That's going to be in the will. But for a will to be effective, it has to go through a probate process, meaning a court overseen process, in order to ensure that creditors are minded, that last year's taxes are paid, any other governmental obligations are managed, and then your assets are then transferred to your beneficiaries or heirs. A trust, on the other hand, is a document that's more like a vehicle, an entity, a bucket that you could put stuff into while you're alive, and you can manage while you're alive. And the person who manages it is a trustee. While you're alive and you have capacity, you're the trustee. You're the person that manages your bucket. But if you're incapacitated or after you die, you can choose who manages the bucket for you, and they don't need to go through court or have a court overseen process in order to do those things. And what that allows for is a far more efficient way to manage your assets. One, you could pass on assets again without court oversight. You have more leverage against creditors because they don't have a platform in the probate department that allows them to be heard. You could handle your taxes or other governmental obligations in a more effective manner. And ultimately, you could pass on your assets to your heirs without that oversight, intrusion, and expense of a court process. And so for folks who are looking for privacy, folks who have assets greater than 185,000, folks who have real estate, folks who have a variety of heirs and beneficiaries that they want to give to, the trust is really the effective tool to make sure that all of those things are handled for you. It's not the only document. If you have a trust, you always also have a will, but that is really a pour-over will is what we call it at that time. It's really there just to allow somebody to act on your behalf in case they need to for some assets after you die or for some responsibilities, but the heavy lifting goes to the trust.